Hey everyone, today we're unpacking a really high-stakes legal drama that went all the way up to the Supreme Court of the Philippines. We're looking at the case of Banta versus Equitable Bank, which, by the way, is now known as BDO Unibank. This isn't just some messy story about a broken marriage. It's actually a foundational lesson on how financial institutions are legally required to handle the assets you entrust to them. Okay, let's dive into this.
I want you to really put yourself in the shoes of our petitioner, Remedios Banta. Imagine discovering, literally completely by accident, that the real estate you jointly own has just been mortgaged to a major bank for millions of pesos. You never signed a single document, you never stepped foot in the bank, you never saw a single cent of that loan. Yet your properties are suddenly on the hook because your signature was expertly forged. You'd probably be thinking, how on earth could a massive banking institution let this happen? Well, that is the exact nightmare Remedios woke up to, and it sparked a legal battle that completely redefined how strictly we judge the actions of banks. So here's our roadmap for this explainer. First, we'll cover the multi-million peso forgery. Second, the lower court battles. Third, the extraordinary diligence rule. And fourth, the final judgment.
All right, starting off with part one, the multi-million peso forgery.
The deceit in this case escalated so fast. Remedios and Antonio Bonaleta got married back in 1975, but by 1991, things went south, and they actually separated. However, those legal ties of their marriage, they remained intact, specifically regarding their jointly registered properties over in Malabon City. So, fast forward to September 1994. Antonio marches into Equitable Bank and executes a deed of real estate mortgage. He uses Remedios' forged signature to secure a loan of 1 million pesos. But get this, he doesn't stop there. By May 1995, Antonio, teaming up with some relatives, executes an amendment to real estate mortgage. Once again, he fakes his wife's signature, puts up additional collateral, and secures loans now totaling a staggering 4.5 million pesos. And poor Remedios, she had absolutely no idea until June 1997.
Now, it's absolutely crucial to point out that Remedios' claim of forgery wasn't just some he said, she said scenario. When she took this to the regional trial court, the forgery was definitively proven. We're talking unrebutted evidence presented by literal handwriting experts from both the Philippine National Police and the National Bureau of Investigation. There was absolutely no doubt here. Antonio faked his wife's signature to siphon millions from the bank.
Which brings us to part two, the lower court battles.
So going through the lower courts, there was this massive disconnect between finding the bank at fault and actually making them pay up. The regional trial court totally agreed the mortgage was void because of the forgery. They even pointed out that Equitable Bank was negligent for accepting the properties without double-checking Remedios' signature. But, surprisingly, they didn't order the bank to pay any major damages. So both parties appealed to the Court of Appeals. The CA grants Remedios moral and exemplary damages, but, and this is a big but, they explicitly let the bank off the hook for joint liability. The CA basically said, well, there's no proof the bank actively conspired with Antonia, so they weren't in bad faith, therefore they shouldn't have to pay.
This sets up the core conflict as the case rockets up to the Supreme Court. On one side, Equitable Bank's defense is essentially, hey, we didn't conspire with this guy, we weren't acting in bad faith. Sure, maybe we were a little negligent, but mere negligence isn't enough to make us pay damages. On the other side, Remedios is arguing, wait a minute, you aren't just some random person off the street, you are a massive banking institution. Your extreme negligence in failing to verify my signature should absolutely make you liable for this entire financial mess.
And that leads us directly into part three, the extraordinary diligence rule.
When the case finally lands on the desk of the First Division of the Philippine Supreme Court, they completely shut down the bank's defense. So, the crucial point here is this legal doctrine, extraordinary diligence. The court made it crystal clear that a bank cannot just skate by on ordinary care. Because a bank's whole business is so deeply tied to the economy and the public interest, they are legally required, and frankly expected, to exercise the absolute highest degree of diligence and integrity.
I want to read this exact quote from the Supreme Court because it really anchors this whole precedent. The court stated, since their business and industry are imbued with public interest, banks are required to exercise extraordinary diligence, which is more than that of a Roman paterfamilias. Now, in legal terms, a Roman paterfamilias basically means a good father of a family. It's the baseline standard for just ordinary, reasonable care. The Supreme Court is literally telling banks, ordinary is not enough for you. You have to be exceptional. You can't just glance at a title certificate and assume everything's golden. You have a strict duty to dig deeper, verify those titles, and meticulously inspect both the properties and the people you're doing business with.
And this brilliantly illustrates exactly where Equitable Bank dropped the ball. They skipped the most basic safety measures. I mean, the bank couldn't prove Remedios participated in the loan application in any way whatsoever. Not a single bank employee ever dealt with her directly. And remember, she's a registered owner of the collateral they were taking. They totally failed to verify if her signature on the amendment was genuine. They literally just took Antonio's word for it. By completely failing to check if Antonio actually had authority, the bank fell incredibly short of that extraordinary diligence standard.
All right, let's wrap this up with Part 4, the final judgment.
The Supreme Court did not mince words here. Because of their severe lack of due diligence, Equitable Bank was officially declared not a mortgagee in good faith. The court ruled that this level of carelessness actually constitutes a quasi-delict. Now, if you aren't familiar, a quasi-delict is basically a civil wrong caused by negligence. So that whole argument from the bank about needing to be in bad faith or in some secret conspiracy with Antonio, completely thrown out. Their negligence alone was more than enough to make them fully accountable. And of course, accountability comes with a price tag. The Supreme Court established a baseline figure of 100,000 pesos. But here's the kicker. This wasn't just awarded once. This is the baseline figure applied across multiple categories of damages that the bank, again now BDO Unibank, has to pay jointly and severally with Antonio. Let's break down what that actually looks like.
So, joint and several liability basically means Remedios can go after either Antonio or the bank for the full amount. If the bank pays up, well, they have to chase Antonio for his share later. The penalties broke down like this. First, 100,000 pesos in moral damages. Under Civil Code Article 2220, this compensates Remedios for all the psychological trauma she went through. Second, another 100,000 for exemplary damages. According to Article 2229, this is a penalty meant for the public good. It's awarded specifically to set an example, reminding the whole banking sector that they have got to maintain meticulous service. And finally, 100,000 in attorney's fees, because, let's face it, the bank's negligence practically forced Remedios to spend years litigating just to protect her own property.
This case perfectly encapsulates the ultimate lesson for the financial industry. Banks are simply not allowed to be careless. They make a sworn profession of diligence to the public. If they fail to do basic verification, if they cut corners, or if they just blindly accept paperwork handed to them by one spouse behind the other's back, they are going to be held financially responsible for the fallout. They absolutely must guard against injuries caused by their own negligence.
Which leaves us with a pretty critical thought for all of us consumers. We trust these institutions with our livelihoods, our homes, and our life savings. This case proves that the law demands they protect that trust meticulously. But it really begs the question, is your bank exercising extraordinary diligence with your assets? Definitely something to keep in mind the next time you sign on the dotted line. Thanks so much for joining me on this explainer, and as always, keep asking the big questions.